Good morning, my dear friends. I am Haribabu, High Court, advocate at Hyderabad. I started this video series to bring to the knowledge of the listeners the particulars of the Constitution. I have studied Constitution for about 5 years and wrote a book called Indian Politics versus Indian Constitution and published it through Notion Press, Chennai. The same is available online worldwide on Amazon, Flipkart and Kobo. I found that whatever is happening on social, political and economic fronts in India in the name of the Constitution is not in accordance with what is stated in it. As a result, there has been conflicts of social, political, economic, geographical and linguistic, and it resulted in utter poverty and a huge gap between haves and the have-nots. It is time to fix the problem and seek solutions. I hope every citizen will admit that there are serious problems in India. In the previous video, I discussed about socialist and secular and informed you that India cannot be socialist, secular or even federal. These are the misnomers, these are the illegal concepts that are spread around in the country. While making those discussions, I refer to a case called SR Bommai case, in which the Hon'ble Supreme Court held that Indian federal structure should be preserved and that elected governments in the state should survive. With great respect to the Hon'ble Supreme Court, I submit that there won't be elected governments in the states. And India is not federal. By the way, it is understood in India. Federal means it only denotes central. In America, federal government means it is a central government. Federal court means it is the central court. In India, we call union government. Because the very first article says that India, that is Bharat, shall be a union of states. It did not say that India, that is Bharat, shall be a federation of states. But in fact, my dear friends, I tell you, there is no wrong in calling either federal or unitary. These two terms refer to the same meaning, that is central. If you say it is federal structure, you should understand that it is a central structure. Federal does not denote the relationship between state and the center. Federal states only that it is central. As such, the SR Bommai case, in my opinion, is not constitutional. And whether your country is federal or unitary, the very purpose is to secure its unity, integrity. Under Indian constitutional system, there won't be elected governments of chief ministers in the states, nor governments of the prime minister at the union level. And the system is such that people elect MLAs, people elect Lok Sabha members, and MLAs elect the Rajya Sabha members. All these three are called electoral college. They elect the President of India under Article 55, in which issuing of whip is also prohibited under Article 55(3). So that is the genuine election. Not only that, the Constitution prescribed only two types of elections, to the legislative and the executive in India under Article 324. The responsibilities entrusted to the Election Commission are only elections to the legislatures and election to the post of president and vice president, of course. Election of chief minister and prime minister in the legislatures is not contained in Indian constitution. It is contained in Pakistan constitution under article 91 and 130. Again, losing of position as prime minister or chief minister through no confidence motions is contained in article 95 and article 130 clause 5 in Pakistan constitution, but they are not contained in Indian constitution. So we should understand that President of India is the only elected executive in India according to the constitution, whereas election of chief minister and prime minister are not contained in Indian constitution. I will bring to you a situation where no single party gains majority in the assembly or the parliament, whereby a chief minister or a prime minister could be elected by a single party. In that case, coalitions are being formed. So the executive, the president or the governor. So first let us speak for the state. The governor invites the leader of the single largest party to form government and gives him time 10 to 15 days time to prove his majority on the floor of the assembly. Then the whole drama starts. He collects all the supporting MLAs and hides them in resorts somewhere. There the matters of money, positions and everything are fixed, and then they will be brought before the governor of that state and ask him to now conduct voting. These political parties issue whips. Whip means a member should attend the election and vote for the party, vote for the candidate who is decided by the political party, and they should show it before casting their vote. They should do it openly. Please consider, we cannot ask a wife or a husband to whom he or she voted or would vote. You see, these MLAs and MPs have to vote according to dictates of the party and openly. Is this not false, funny and shameful practice? In fact, we are deceiving ourselves in the name of the democracy. Such an election is not contained under the Indian constitution. According to Indian constitution, I told you, the president is elected under Article 55 and he forms his government at the union level under Article 74 and 75. Article 74 says that there shall be council of ministers to aid and advise the president in exercising his duties, with prime minister as head. And Article 75 says the prime minister is appointed by the president of India and the other ministers are appointed by the president of India on the advice of the prime minister. And clause 2 comes. The terms of office of ministers shall be during the pleasure of the president. So they are appointed by the president and their terms of office is during the pleasure of the president. There is no question of election in the assembly or the Lok Sabha, or there are no confidence motions. As regards states are concerned, president appoints governors under Article 154 and they come to states and they should form their governments in the states under Article 163 and 164. Again, 163 says that there shall be council of ministers with chief minister as head to aid and advise the governor in discharging his functions. And clause 2 says that the terms of office of ministers shall be during the pleasure of the governor. Here the terms of office of ministers includes chief minister because the total number of ministers at the union level or at the state level shall be 15% of the strength of the Lok Sabha or the assembly here, which includes the Prime Minister and Chief Minister within that 15% ceiling. Especially in states, Article 163 and 166 says that the minister shall not be eligible to advise the governor in matters which require his own discretion. Under Article 166, the governor is not supposed to delegate such of the powers to the ministers in matters which require his own discretion. Article 167 and Article 78 both suggest that the Prime Minister and the Chief Minister shall report to the President and the Governor regarding all administrative and legislative proposals. And all governmental business shall be conducted in the name of the President or the Governor. It means that if an NDA President is elected, there will be NDA governments throughout the country. If UPA President is elected, there will be UPA governments throughout the country. Please imagine a situation, then would there be conflicts between a state and the state and the center? Or can any chief minister can imprison the ex-chief minister? There won't be conflicts of force between interstate or intrastate. So there would not be midterm elections or dissolution of assemblies in the middle. So the country will be peaceful for 5 years and prospering. There will be elections only every 5 years. There will be election of president midterm if he resigns, dies, or otherwise becomes disqualified. Otherwise, what is the meaning of conducting midterm elections to the states at the behest of the chief minister, who is a political person? So, please understand, my dear friends, the judgment of the Hon'ble Supreme Court. With due respects to the court, I say it is wrong on both the counts, that there shall be elected governments in the states and that federal structure of India should be protected. Whether you call the country federal or unitary, it doesn't matter. You can call anyway, but the center-state relation should be governed by the express provisions of the Constitution, not by the term federal in whichever fashion one understands. There are express, very elaborate system arranged by the Constituent Assembly and Dr. Ambedkar. Unfortunately, we are flouting the provisions of the Constitution and conducting the country according to our convenience, finally which will lead to breakup of the country. For today, I take leave, and today I refer to a case called previously, of course, Keshavananda Bharati case. Tomorrow or the next video, I will be informing you how Keshavananda Bharati case was basically wrong. And after that, I will explain you what are the dangers of elected governments in the states through chief ministers and prime ministers. Thank you. Thank you for watching. Please don't forget to subscribe, share and comment on my videos. My endeavor is to bring the Constitution to the knowledge of the citizens of India, and whatever comments you make, I will make endeavor to reply them through a reply video or through you directly. Thank you. Thank you.